My joy to be with you today. I very much appreciate the opportunity to come and speak. I was telling Dr. Benson earlier, it hasn't been all that many years ago, maybe about 15 years ago. I actually taught in this building. I taught over in the aerospace department and taught aviation law. I've been teaching at the law school in Nashville since about 1999. It's a night law school, and you can get your law degree there in 4 years of part-time study after you graduate from college. And the program there is designed so that you can work during the day and go to school in the evening. And the plan, at least, is that you can graduate from law school without any additional student debt, which of course is a big deal, I know, to most of you who are students. Let me put in just a matter of personal privilege, if you will. Let me put in one quick word for my friends at the MTSU Lions Club. I don't know if any of you folks are involved in any civic activities or organizations. I'm real active as an adult in the Lions Club, and we just started a new group of students here who were in the Lions Club here at MTSU, and they're concentrating hard on working on service projects and working to make the campus a better place. So if you're interested in a service project, check out the MTSU Lions Club, if you will. Let me talk to you for just a few minutes first about the court system generally, and then we'll get into the case that we're talking about. First of all, I guess all of us know that within the court system, the court is courts are one of three major branches of our government, right? The executive, legislative, judicial. We're the judicial branch, and a lot of folks say we're the least powerful, but maybe we carry the biggest stick, because in fact the courts, of course, can declare a law to be unconstitutional. We can put down an injunction to prevent the enforcement of a law that is not appropriate. There are both state courts and federal courts, and of course within the federal court system, the purpose of the federal court is to deal with cases where there is a federal question, often a constitutional question, but at least a question that involves aspects of the federal law. The federal court system has a lot of specialty courts, tax courts, and I know you all are, many of you, accountants, right, in this class, so you may become familiar with some of the specialty types of courts, the bankruptcy court and so forth. Otherwise, outside of those specialty areas, the federal court system has a district court, which is the basic trial level court, which is court like we think about it, where lawyers come in, sometimes a jury, sometimes just a judge hears the cases, and the case is actually tried with witnesses and that kind of thing. If a decision is made there that one of the litigants doesn't like or doesn't want to live with, he or she can appeal, and the next level up in the federal system is called the circuit court. There are circuits that serve several states, and the area that includes Tennessee is the 6th Circuit, and it holds court in Cincinnati, Ohio. So if you have a federal court case here in Middle Tennessee, you would go to the district court in Nashville. If there's an appeal from there, it would go to the circuit court, the 6th Circuit in Cincinnati. And then appeals from there, of course, go to the U.S. Supreme Court in Washington. One aspect about the federal court is that after you go through the circuit court level, before you can get to the U.S. Supreme Court, that court has to make a decision and say, we want to hear this case. In other words, you apply to the court, and the court can say, we're too busy. We don't think there's sufficient novel issues involved in that case, or for whatever reason, the court may just say, you know, we're going to deny the right to appeal. So our U.S. Supreme Court really hears very few cases. Generally, under 100 cases a year will actually be tried there. And you may be surprised at the way the courts do at the appellate level. It's not a situation where you bring witnesses in and you present your arguments and you present the testimony of the parties. None of that happens. What happens is that the trial actually occurs in the district court in Nashville, and every case after that, every court after that, including the U.S. Supreme Court in Washington, the judges read the record, they read what that testimony was and what the evidence showed at the trial level, and then they hear the arguments of the lawyers, where the lawyers argue the law, and then the Supreme Court makes a decision. The U.S. Supreme Court may decide the case. They may reverse it actually comes to the U.S. Supreme Court from the Circuit Court, so they may reverse the Circuit Court. They may do what the trial level court did. They may find something totally different, or they might reverse and remand. Remand is the word that all judges hate to see, because that means they're sending it back to you to say, try it again. They'll say, apply this different law or a different set of circumstances. Don't let this expert witness testify, or allow this evidence to come in, or something along those lines. Try the case differently, and they remand it to the trial level court for a retrial, another hearing. That's over on the federal side. Now, in the state court, and our Scales program, of course, is a state court program, and we'll get into that case here in just a few minutes. But in the state court, it's somewhat the same situation. We have at the top, we have our Tennessee Supreme Court. Our Tennessee Supreme Court consists of 5 judges. At the U.S. Supreme Court, there are 9. But in Tennessee, we have 5 judges on our state Supreme Court. And those judges, just like the judges in the U.S. Supreme Court, they hear cases just based upon the arguments of the attorneys and the briefs that the lawyers write. And the judges on the state Supreme Court will read the record of the testimony, read the record, and by record I mean the questions asked by the lawyers, the answers given by the witnesses, and they'll read any exhibits that are introduced. And an exhibit sometime is a piece of paper. Sometime in a case it may be a contract that the parties have entered. It may be a diagram. It may in fact be an object. Occasionally you'll see some real crazy exhibits. You may have in an automobile accident case, in rare occasion, you may have a wrecked car, which is an exhibit in a case. Well, how do you get that into the courtroom? Obviously you don't, but generally photos are presented, which more frequently are the exhibits that are introduced. But occasionally you'll see an object that is introduced and is a part of the record. I've had concrete slabs where somebody alleges that in a construction case the concrete was not properly put together and so forth. At any rate, all of that is included within the record of the cases, and the record then goes up to the Supreme Court. Now, before it gets to the Tennessee Supreme Court, a case has to go generally through the appellate court level, which is an intermediate court, maybe like the circuit court in the federal system, the Court of Appeals, or for a criminal case, the Court of Criminal Appeals. Each of those have panels of 3 judges that sit and hear cases, and they, just like the state Supreme Court, they read the record that has been developed in the trial court. Below the Court of Appeals then in Tennessee is the trial level court. Now, there are generally 2 types of trial courts in Tennessee. The circuit court is the primary trial level court. Circuit court is considered what we would say a court of law. There is also a chancery court. Chancery court is considered to be a court of equity. What is interesting is that there are only 3 states in America that have a separate chancery court and circuit court. In every other state besides those 3, cases at law and cases in equity are bound together and are tried by the same court. And you may say, what do you mean cases in equity? Equity cases simply mean an equity case is a case where someone has sued in a civil court. Now keep in mind difference in civil and criminal. Criminal is where we're trying to find somebody guilty or not guilty, and if they're guilty, we punish them, send them to jail, put them on probation, those kinds of things. Civil court is where one person sues another person, or one company sues another company, or sometimes, a company sues an individual, any of those types of things. Typically, when somebody sues another person, they want money. There's been an automobile accident, tragic accident, somebody ran a stop sign, car's been totally destroyed, people have been killed, people have been seriously injured, people are suing for the hospital bills, for their lost wages. Sometimes they're suing for what we call wrongful death, where somebody has unfortunately been killed through that accident. Or it's a contract action, where parties have there's a contract and one party has done what he's supposed to do and the other party hasn't, and the one that's done what he is supposed to do, he files suit against the other guy and sues him for breach of contract. But generally he wants money, and he wants damages because in fact the party who has failed to follow the terms of the contract then has damaged him, he alleges. All of those are cases at law. All of those come in the circuit court. The Chancery Court hears cases where people don't want money. And you may say, gosh, I thought when everybody files suit, I thought money was what people sued for. What else would they sue for? Well, sometimes when you have two landowners, oftentimes happens out in the country, two landowners where they have adjoining tracts of land and their deeds to their property may not be too exact, or the way they're written, it seems like the properties overlap. So one sues another and wants the court to go through and draw the boundary line. Don't want money, just want a judgment saying what where the boundary line is. Occasionally we'll have a situation where there's a new factory that somebody puts in. And this factory, unfortunately, is right near a residential area or right in the middle of a residential area. And of course that factory puts out that smoke, and it's uncomfortable. It's not pleasant for the residential community right beside it. So the homeowners may get together and they may want to file a suit against that factory, wanting that factory either to cease operations or to change their way of manufacturing, or to change the way they're doing things so that they don't put out the noxious fumes or that kind of thing. What do they want then? They want a court order ordering the factory to change the way they do things or to stop doing something. In the law, we call that an injunction. And chancery courts deal with injunctions. There are actually two types of injunctions. One, to make somebody stop doing something, which is a preventive injunction. And then there are injunctions to make somebody start doing something that they ought to have been doing all along, and they haven't been doing, and courts would order that, and that's a mandatory injunction. And that again is something that the Chancery Court does. Also with contracts, we have cases, admittedly only occasionally, very occasionally, but we have cases where somebody will allegedly breach a contract and they sue, and they don't want money. They want the court to order the other party to perform the terms of that contract. Typically, courts won't do that, but where the specific enforcement of contract is what we call it, specific enforcement of contract, where that is sued for, that too is an equity action. So if hypothetically we have a situation where two folks go in and they have determined that they can't have children, and they decide that they want to pay somebody a sum of money to be a surrogate, to have a child for them, and that person has the child and then decides, I know I've gotten all this money, and I know our contract or our agreement says at the time the child is born, I surrender the child, but I've decided I don't want to. In some views, that might be considered a breach of contract. And of course, the people that were supposed to get the baby could bring an action in circuit court for money judgment. How much have they been damaged because this other party breached the contract? Or they could bring an action in Chancery court and say specific enforcement of contract. Why? Because money damages is insufficient. Based upon the circumstances here, we contracted to have a baby, and every baby is unique. Maybe we can all agree with that. Every person is a unique person, and there's no way that we will be satisfied. There's no way we'll be made whole, is what we say in the law. No way we'll be made whole unless we have an order specifically enforcing the terms of that contract. Well, those are all hypothetical types of cases, and I will tell you the In re Baby case that we're going to talk about in just a moment didn't come through the courts in that way. It didn't come through either Chancery court, actually, or Circuit court. As you probably read, and I assume this case has been made available to you, and I know it's rather lengthy by the time you read all the briefs and attachments and all of that, but that case came up through the juvenile court. Now, juvenile court is not a court of general jurisdiction. Juvenile court is a court then which typically deals with matters involving children, involving minors. Minor defined as one person under the age of 18. Typically, juvenile court will deal with issues where a child, one under 18, has violated what otherwise would be a criminal statute, and in fact, if the person were an adult, he or she would go to criminal court for a determination whether he's guilty or innocent, and if guilty, he'd be punished. If he's under the age of 18, or she, then those matters go into juvenile court. Juvenile court also deals with what's called unruly petitions. Now, you may see a bunch of adults that are unruly, but if you're an adult, it's not illegal to be unruly. If you're under the age of 18 and you don't go to school like the truancy laws require, if you don't follow the rules at your household, if you otherwise are just disorderly, I guess is a good way to put it, a unruly petition can be brought against you in the juvenile court. Well, those matters all, if they are appealed, and I'll go ahead and tell you that every court except the United States Supreme Court, which of course is final, makes final decisions, every court anywhere along the way always has a court above it where an appeal can be taken. Generally, juvenile court appeals go to the circuit court. There are some instances, and rare is probably too strong a word, but some instances where a juvenile court makes decisions which, rather than going up to circuit, go directly to the Court of Appeals, just as a circuit court or chancery court decision would. Juvenile court then also has jurisdiction to make determinations in cases involving paternity, where parties aren't married to each other and there is some question as to who's the father. Usually not much question who the mother is, but where the question is who's the father, the juvenile court may make that determination. And of course they do that after scientific testing and so forth takes place. The action in this In re Baby case initiated or started in the juvenile court in Nashville. And you may say, gosh, that's a funny name for a case. I agree with you. Most times, and you've probably studied some cases before, most cases are, if it's a criminal case, it's state or state of Tennessee versus whoever the defendant is. State versus Miranda, or if it goes up to the federal U.S. Supreme Court, it's usually the name of the state. It's Arizona versus Miranda, for example. In some cases, though, you can have a suit where the party or the named party is the thing in controversy or the thing at issue. We have a case that I just taught last week in law school where it was in re 154 acres or something like that, where there was a tract of 154 acres and the ownership and use of that property was at issue. Occasionally you'll see a case where it'll be in re, and in re means in the matter of. Sometime it'll be in the matter of $2 million or something along those lines. Here, the thing at issue is this child, this baby. So while the case could have been styled, the plaintiffs versus the surrogate, it also could have been styled in other ways for purposes of the juvenile court here. They styled it when they filed it just in re baby, meaning that the child is what's at issue. That's what we want the court to decide, and that's what we're going to name the case. Let me see how we're doing on time. I guess we're about 25 minutes into it. I always talk longer than I mean to. Let me stop and see what questions you got to this point. Questions on our court system generally, or questions about courts, or initially about this case? Well, let's talk about the case, and I don't want to be unfair to anybody. Have you all had the case? Have you had the chance to read it and so forth? Let me suggest to you that within the case, I think there are two central issues that the court had to deal with. The opinion doesn't say this, but in reading through it, what I glean is that the court on one side had the issue of the contract. There was no question but that these parties, the folks that lived in Italy, they entered into a contract with the surrogate who lived in Tennessee. The court then generally will consider if there are persons involved with the proper contract, we generally will enforce the terms of that contract. So we have the contract on one side. Then on the other side, we'll have what I'll call public policy, meaning that separate and apart from the contract, we have to recognize, we the courts, we the people, we the citizens, we have to recognize that in fact there are some instances where we ought to say, despite what these parties may have agreed to, there is a policy involved that requires us to do something different other than to enforce the black letter terms of that contract. So the court then considered, I'll suggest to you, those two things. So if we have a contract, ideas as to what you have to make the contract valid and enforceable? Some ideas. What do you have to have a valid contract? Lacey, what do you say?
You've got to have a signature of some kind.
Got to have a signature, absolutely. You've got to have the approval of the parties, and on top of that, they have to be competent parties, parties that are competent to contract. Other ideas. Tom, what else do you have to have?
There was consideration.
Consideration, absolutely. And what is consideration, Cora?
You have to, I don't remember the definition.
You have to have something that makes the contract enforceable, where one person does something or gives something. For example, in this case, there was money involved, and I don't remember how much.
$30,000.
$30,000, and then maybe some more for medical bills or something like that. So a bunch of money. And all of that money then was consideration. Was that the only consideration? I'll say probably not, because in fact when somebody does something to their detriment, that in fact could be considered consideration as well. The fact that the surrogate allowed the embryo to be implanted and so forth. This isn't a biology class, but to have the medical issues develop so that she then would be able to carry the child. That, in fact, I would suggest to you might be considered to be consideration on her part. We also say that there must be an offer and an acceptance, and that's easy in this case because one of these parties made an offer. Perhaps the folks in Italy made the offer because they wanted to have someone carry a child for them, and then an acceptance, which is where the lady in Tennessee then agreed then for the sum of money and under the conditions that were stated to carry the child. So all of those things have to exist then for a valid contract to take place. And the other, the one issue that we didn't talk about is that there must be a legal purpose contrasted with an illegal purpose. Obviously, if you have a contract where somebody agrees to buy or sell a significant quantity of illegal narcotics, obviously that would not be enforced by the court because it's an illegal contract. What about a contract to have a baby? Is that a legal contract or is that an illegal contract? What do you think? And my eyes are so bad. Lucas, what do you think? Is that a legal contract?
I think it's legal.
Think it is legal? Okay. And why do you think so? Because the court found so, right? Yeah, I'm with you. Drew? Okay. The court then has to consider whether we're going to enforce the terms of that contract, whether we're going to completely ignore that contract, or whether we're just going to order money damages, I guess. Do you think? What would you do if you were the judge, sir?
I would enforce it.
Enforce the contract? Enforce the contract? And does it matter? You're going to have to help me. I can't see that far. Ashley, does it matter that these folks don't even live in the United States?
It does matter because they signed the contract.
Okay. So if we enforce this contract, then we're going to send this little baby who's born right here in Tennessee over to Italy to live? You okay with that?
No.
No? What's your name?
Brooke.
Brooke, what do you think?
I'm not sure.
Not sure? Okay, let me ask you this, Brooke. I think the proof shows that at the time of the entry of the contract, these folks in Italy weren't even married to each other.
And it's not legal.
Okay, all right. Bradley, does that trouble you or not?
Yeah, because I think in the case it said that they were married or something like that. It kind of gave the impression that they were married during the contract.
And I think the proof showed that probably right about the time the baby was born, somewhere in that time frame, that they did go ahead over to Franklin, over to Williamson County, and they did in fact marry. But they were not married at the commencement of the case. Comments that you got? Is it Leela?
That's right. Yeah.
All right.
I think the challenge to stay in the U.S. because there was already a violation in the contract because they were married. And it could be a fraud in execution that they say that they're married, but they actually aren't. So they're trying to create fraud. So challenge to stay here.
Okay. There was some talk also about the fact that there was a statutory provision, and perhaps we're all aware that our law is made up of statutes passed by our legislature or on the national level passed by Congress. So our law is what the legislature says the law is and what our courts have decided or what our courts have included as a part of the law. There is a statute involved here which seems to imply that where there is a surrogate And perhaps we recognize that the statutes in Tennessee do recognize surrogacy, just as Lucas told us earlier that surrogacy is considered to be legal here in Tennessee. And the statute dealing with surrogacy has language which indicates that in fact we're going to contemplate that the parties who pay to have the baby born, that those parties are in fact husband and wife, because the law talks about the guy donating his portion, and then when the child is born, the child goes to the man and to his wife. So there's some consideration, and that certainly is an issue that the surrogate has raised as far as this issue is concerned as well. Another issue that the surrogate raised is the fact that when she was at the juvenile court level, Lacey, she didn't have a lawyer. And she says, you can't enforce a contract against me because I wasn't represented by an attorney at the time. What do you think?
She's still competent. If she wanted a lawyer, she should have got one.
Okay, all right. There are some cases where the courts have said, you know, you can't go forward unless the person has a lawyer or the person is appointed a lawyer. In a DUI case, driving under the influence of an intoxicant, if a party goes to court, pleads guilty to DUI, doesn't have a lawyer at that DUI hearing, he's still guilty and he still serves the sentence. But if later he gets caught for DUI again, there are higher penalties for second offense DUI. And the law says that if somebody's charged with second offense DUI and we look back at their first offense DUI and they didn't have a lawyer at that time, it is difficult to make a case stand for second offense DUI because the courts say, well, he didn't have a lawyer the first time. It wasn't made known to him that in fact the higher penalties would be imposed on him if he was charged with DUI again. In adoption cases, and I'm not talking about surrogacy, I'm just talking about where we have a mother and a father and somebody else wants to adopt the children. If the biological parents oppose that adoption, in other words, they don't want their legal rights to be terminated, then the law says that they either have to hire an attorney, or if they're unable to hire an attorney and they want representation, the court is required to appoint an attorney for them. So I think that's where this lady is kind of coming from on the theory that she didn't have a lawyer and no lawyer was appointed for her at the juvenile court level. One factor that seems real obvious to me, though, if you want a lawyer appointed, you got to request it. And there has to be some showing of some indigency, and I think probably she was indigent. I think that was shown, but in fact, it's clear also that she never requested that an attorney be appointed for her. Well, let's see. The issue, I guess, that from a contract standpoint that we have not talked about, and I'm not sure any of the parties in their briefs talked about this, but where two parties are involved in a contract or an issue, even if we find for whatever reason that we shouldn't enforce the terms of that contract, and we're looking at from a legal from an equitable standpoint, there may be some question raised as to whether the parties have treated each other fairly. In other words, Anthony, there has to be, if there's a situation where one party has taken a position and another party then has altered his position based upon what the first person said they were going to do, then we say that that first person is prevented from changing his or her mind based upon the fact that he's made a representation that the other party has relied upon and taken action to his detriment upon. We call that principle estoppel. Funny word, E-S-T-O-P-P-E-L, estoppel. And we also say that someone is estopped or prevented from taking a contrary position. So my question, sir, do you think there's room for some discussion that perhaps the surrogate in this case might be estopped, as we say under the law, from changing her mind or changing her position based upon her statements and her actions?
I'd say yeah.
Maybe, maybe not. Yeah, perhaps so. Perhaps she might be able to change her mind, but at the same time, pretty clear that these folks went through a long period of time before the conception, if you will, conception of the child ever took place. So I suppose she had plenty of opportunity to make her decision, make her change, and she, of course, waited. As I understand the facts, she at least alleges that her change of her mind or change of heart occurred really after the baby was born and after everybody agreed that she would keep the child just a couple of days, nurse the child and so forth. And during that time, she became bonded with the child. My understanding is that the child was born at home with a midwife, and that the surrogate and her husband, boyfriend, I'm not sure which, but that they had separated shortly before the birth of the child. So the surrogate then was living in a very small apartment, but the adoptive father, prospective adoptive father, came there to her apartment. He didn't stay all night because the apartment was small and because they didn't think it was appropriate for him to do so, but he came early in the day, stayed pretty well all day, and helped to care for the child. Well, when we look at all of these matters, if we look at the remedy, then Anna, what do you think? What is appropriate in this case? Do we render a decision where we enforce or specifically enforce this contract, or do we order money, or what do you think is an appropriate remedy?
I feel like they should never allow the surrogate mother to spend that much time with the baby if they knew they were gonna want to take it home anyway, because they knew that was gonna happen. It happens with every mother and child.
Well, good point. Good point. And if they did that, do you think maybe they miss out on their opportunity now to take the child home? Maybe so. Might be what we would consider in the law to be a waiver. In other words, the contract terms said that immediately upon the birth of the child would be surrendered by the surrogate to the prospective adoptive parents. The prospective adoptive parents then agreed with the surrogate that in fact she could keep the child, nurse the child briefly, and that type of thing. So not sure either party talked about that in the pleadings, but gosh, we got a lot of things that nobody talked about here that may in fact develop as an issue. I walked over here and I forgot it already. Henson. Yes, sir. Another issue that nobody really developed that I had concern with, you know, the parties wanting to enforce this case lived in Italy, or live in Italy, and it looked to me like the surrogate lived in Bristol or Johnson City up in Sullivan County, or maybe Washington County up in there. And here's this lawsuit in Nashville. Any explanation of that?
I believe it has something to do with the federal law we have been broken. That there is a clause that if it is a federal issue, it can be dealt in every state.
Okay, all right. Now, and you're right, but now here we're talking about a state law rather than federal, but I think you are on the right track. I think they considered that the issue probably was one that has some significance as far as the validity of the statute, even though that they didn't pursue that and that wasn't ultimately developed. Certainly the law says that if you have such a case, then Nashville courts are the place to proceed with that. And frankly, the facts may have developed. I'm not sure either side fully developed that issue and nobody raised it as a question. But the fact may have developed that the child may have been brought to Nashville for some other purposes, and I don't know what the facts are as far as that's concerned. Well, Allie, when you look at all of these matters from a contract side, we're really leaving out the issue of public policy. And from a policy standpoint, do you think we ought to allow people to contract for babies and to pay money and for somebody to have a baby that they aren't going to keep and give up immediately? What do you think?
I don't know. I felt weird putting it that way, like selling babies. But I don't know what's legal in Italy either. Can you?
Ooh, that's a good question. And I don't know either. The contract did say that we were going to look at Tennessee law. And under contract law, you can do that. You can specify that some law, as long as it's the law of a state that has some application that you can contract or agree for that particular law to apply. Let me just briefly mention a couple of other side issues because I think I've about talked myself out of time here. One question that I'm not sure was fully developed, the juvenile court in Nashville decided this case actually before the baby was born. The juvenile court decided, yes, we're going to enforce this contract and so forth before the baby was born. That may not seem like a big deal, and I don't think anybody raised it, but that may be significant. Generally, you have to look at a child in being, a child rather than a child in the make, a child rather than a fetus, if you will. And I think one of the parties did address that very briefly. The other issue was that, again, nobody raised, was that the contract provided that if there was a dispute that arose, they agreed to arbitrate or to mediate rather than going to court. If they did that, it wasn't addressed as I saw it in their briefs, so there may be some issue that the court may say, well, you know, this contract says that if you have problems, you're going to mediate that or you're going to try to settle it. Well, I've talked longer than I meant to, and I apologize. Let me just ask you on a poll, if we look, there are a lot of issues involved back and forth. Which of you say, yes, we would enforce the contract, we would send the child with the prospective adoptive parents, and which of you say, we would allow the surrogate to keep the child if that were an issue? Who says send the child with the adoptive parents? Okay. And who says let the surrogate keep the child? Okay. And of course, if we had a jury trial, you would have to decide unanimously because you can't have a split vote. Dr. Benson, I've talked longer than I meant to. Are there any questions that any of you have that you want me to address, or any other comments that you'd like to mention before we close for the day? Yes, sir.
Assuming I decide not to be married, but I want to have a child and have so much money, can I pay somebody to have a child for me?
We may find out when this case is over, but at least right now it looks like that's probably the law. we do allow surrogacy, absolutely.
Why is she raising the issue that they were not married before the surrogates?
Say that again, I'm sorry.
Why is the surrogate mother raising the issue that the couple were not married?
Oh, simply because of the wording in the state law, which says, talks about the fact that the surrogate then would deliver the child to the husband or the gentleman and his wife. I think that's the only reason that issue was raised.
I have one more question.
Yes, please, I'm sorry.
Would this not turn into more of like a custody battle? Because technically that is the child's father.
Yes. He's the father and the surrogate's the mother from a biological standpoint. Yeah, good question. And if this were not a surrogacy type of issue, I think that's exactly what you would have. The fact that there was the surrogacy contract where it was never intended by anybody that she would be the mother. There was never a sexual relationship in the normal sense between these parties. I think all of that is what probably makes this different as a surrogacy situation. Yes, ma'am.
One last question I have that might be helpful for the students. In terms of a court overriding and making a decision on public policy, if the statute were clear about the public policy, what room does the court have to override this? And then you might also mention, it seems to me there was some language in the statute that gave a lot of wiggle room. It said we're not really declaring whether we think these are really valid. We're going to leave that to future courts and legislature. Are they asking the court to decide it? And if they weren't doing that, would you be able to just override it based on public policy?
This is a new area of the law. This is an area where not many states have a firm policy. And as you may know, we follow what's called stare decisis, which simply means one court is going to follow what another court before it did. And here we don't have a firm pattern of what we ought to do, what courts ought to say in these types of situations. And because of that, I think there's a whole lot of room for a lot of wiggle room, if you will, within that opportunity for the court. We do have the statute, and the way the statute is worded, I think the court could decide any number of factors. One thing the court could do, the court, frankly, if they chose to, they could dodge the whole thing and just say, juvenile court is not a court that enforces contracts. You sued in the wrong court, case dismissed. It's over. And if they did that, then the parties are left there hanging. And if that were the case, then I guess they go back and sue in the right court, if you will. So I don't think the court would do that, but I've seen other cases where they've done that. They've dodged the issue totally. I would anticipate that the court probably will make a decision here. What they'll do, I guess, is up to discussion. My feeling, just based on my reading of all of it, it would be my thought that probably the court would do as a majority of you said. I think probably the court would enforce it, but there's certainly room for the court to go either way with it. And from a policy standpoint, the court might want to take the opportunity to say, as Anthony was suggesting a moment ago, that maybe it shouldn't be a situation where anybody with a few dollars in his pocket can pay somebody to go have a child for them. And maybe we ought to have a different set of rules and regulations that govern that. You've been very generous. Thank you so much for inviting me, and thank you so much. Good luck when the court comes, I believe, on October 1st. And does this class get to go hear the court proceeding? Well, good luck, and I'll be interested. What the court usually does, of course, you'll hear the proceedings, and they won't tell you at the end how they've decided. So they'll tell you that they'll go back and talk about it and write an opinion later. So don't expect to go in and get an immediate answer, but Don't know how this court will do, but my experience in the past has been that afterwards, a lot of the Supreme Courts, after the case is over, for a limited number of students, they'll talk to you and ask you, let you ask questions about it and that kind of thing. And the lawyers likewise. Of course, the lawyers, they're pushing for their position, but they may very likely be available for questions and talk to you. And you may want to ask them, well, why did you push this issue, or why did you argue that? And I think they'll be most happy to talk to you about it and tell you. Thanks again.
Thank you.